Lordship, I would like to mention item number 16 on behalf of Estapin, Your Lordship.
16.
Yes, Your Lordship. I've taken the consent of the petitioner, Your Lordship. May I kindly take up this matter after vacation?
Ms. Basa, Lanark Government Advocate, appearing on behalf of Mr.
Estapin.
Estapin, Lanark Council for the petitioner, with the consent of the Lanark Council appearing on behalf of the respondent, prays for listing this matter after
Vacation.
the ensuing summer vacation. The prayer is allowed list matter according to the list matter after the ensuing vacation. Okay.
I would like.
My lord, I beg to mention one IA as unlisted matter, my lord, for today, madam. One IA matter, madam, to be listed as unlisted matter for today, madam.
IA for what?
My lord, IA in bail application number 62.
In bail?
In bail, yes, madam.
Bail application
No, my
filed
lord,
by?
actually, what happened, my lord, this Honorable Court, my lord, in AV number 62/2026, my lord, has directed the accused person to execute bail bond of rupees 2 lakhs along with 2 sureties, my lord. Now, my lord, when accused is going for the execution of the bail bond, the OC, the concerned OC is asking the accused person to deposit this particular 2 lakhs amount in case, my lord.
In written, has given in written.
Not in written, but my lord, yesterday I also went along with the accused person. But they're insisting to deposit the amount in case. Where is we have to execute the bail bond only. That is the case. So, my lord, seeking direction to the
Okay.
officers of my lord. That's all.
Tomorrow or today?
Today, my lord.
Today.
Yes, my lord.
Okay.
The accused from Kolkata, my
The last item?
lord.
Okay.
May I, Your Honor?
Yes.
Your Honor, I beg to mention item number 8. This is a first appeal, Your Honor. Your Honor, on the last occasion, the matter was referred for mediation. But due to the absence of the respondent, could not be done. So, I need, Your Honor, the matter may be adjourned and fixed for next date, Your Honor.
Mediation failed.
Yes, the respondent was absent, Your Honor.
Let them at. Oh, okay. We wait for some time. Let us see. Let us see the report, mediation report. Okay. Okay.
My pleasure. My lord, I beg to mention unlisted matter. I have filed one civil revision petition this morning.
Tomorrow. Okay.
Obliged.
Item number 1.
In this item number 1, my lord, we have already filed, my lord, one caveat. My lord.
Lordship, we have not received the caveat for food. The filing of caveat process will be completed after serving of the caveat petition to register post, and by enclosing that receipt, if the caveat file, then of course, Lordship, 148A of CPC says.
My lord, that may be called for, my lord. That caveat.
Caveat file.
We have,
Okay,
yes.
call for. After some time?
Lordship.
After some time?
Lordship.
Did a caveat since he has filed?
My lord, otherwise.
When did you file caveat?
This morning only, my lord.
This morning. Or what?
Or you can take up, my lord, in the meantime, caveat petition will come, my lord. Petitioner may be heard, my lord. In the meantime, my lord, the caveat petition will come, my lord.
Okay. What is this?
May I please, Lordship? Lordship, this civil revision petition is challenging the order passed by the Blaze Assembly, General Assembly of Blaze, Lordship. General Assembly, Lordship. They have decided the civil dispute, Lordship, now. As my Lordship aware, the customary court and the Blaze Authority are the first instance civil court in the state of Arunachal Pradesh, who has the unlimited civil jurisdiction to decide the civil matters, Lordship. But in the present case's hand, Lordship, the impugned cover decision was passed by the Blaze Assembly. May I take you to the Lordship?
What is this new authority?
Lordship.
Village?
Blaze Assembly, Lordship. They are designated themselves as the Blaze General Assembly, Lordship. May I take you to the Impune ex parte Kaba decision, page 63, Lordship. 63.
Hmm.
Annexure 8, Lordship.
Hmm.
Now, this is the authority, special resolution of the General Assembly of DC Blaze Leparada District. Now, this General Assembly, Lordship,
This General Assembly consists of
Lordship, the Gauburas and all the other Blaze members also, Lordship. Lordship, signatory may I take to the last portion. This resolution, Kaba decision was signed by the members of 121 in numbers. 69 is the name of the members who attended the Kaba.
What is their decision?
Decision, Lordship, they decided the disputed land of petitioners as community land.
Based on what?
Lordship, now they are claiming that it was in the possession of the Blaze, since the Blaze has already been established in that area. Therefore, it will be treated as the community land.
Oh, the village decided that
Yes,
otherwise the land belongs to
me, Lordship.
who disputed you earlier?
With the respondent also, same Lordship. For that, Lordship, we have filed a complaint before the Gaubura Blaze authorities.
Okay.
Our first complaint was filed before the Gaubura Blaze authority.
Hmm.
And before fixing of Kaba, Lordship, what happened? The respondent father and the petitioner entered into mutual settlement. Thereby, the deed of declaration was entered by the parents of respondent,
Hmm.
declaring that, yes, we admitted the land belonged to the petitioner.
Mhm.
Thereafter, Lordship, even after that declaration, they continued in encroaching upon the petitioner's land, Lordship. Now, fresh complaint was filed before the HGB for conducting Blaze level Kaba. Now, illegally, what?
No, earlier complaint
Yes,
on the basis of the settlement,
yes.
it was withdrawn or what?
Not, yes, Lordship, because deed of declaration was entered and they sought permission from the petitioner for construction of his residence. Of course,
No,
his
the
residence,
complaint lodged before the village authority was
Yes.
withdrawn subsequently, withdrawn or what?
not withdrawn, but
It was still pending.
closed, Lordship.
It was closed.
Closed because of the deed of declaration, Lord.
Okay.
Now, thereafter, they continued in encroachment upon the petitioner's land.
This is the same person or the son?
Same son, Lordship.
No, the
Earlier,
father. The agreement was, deed of agreement was with
father and the
but then
uncle.
son encroached.
Yes, Lordship.
Okay.
Then fresh complaint was lodged
Hmm.
before Blaze authority.
Hmm.
Now, that complaint was in most illegal manner. The HGB recommended it to the Inter-Blaze Territorial Customary Court,
Hmm.
saying that I was one of the witness to that deed of declaration.
Okay.
Three grounds were given.
Okay.
So, Lordship, may I take you to the debt impute recommendation application, Lordship? Page 35, may I take it, to Lordship? Page 35?
Just a minute. This is impugn order.
Yes, Lordship.
Page 35.
Impute recommendations, page 35, Annex
You are
1.
challenging that this,
Yes,
35 also.
yes, Lordship. Because HGB being the first instance civil court, customary court,
Hmm.
he ought to have taken up the complaint filed by the petitioner, Lordship. But instead of that, they recommended it before the Inter-Blaze Territorial Customary.
Where is your complaint?
My complaint is, Lordship,
37.
yes, 37.
On the same day?
On the same day, Lordship. And on the same day,
No, this was on 22/12/2025. And when this assembly, special resolution of the General Assembly,
General Assembly was held on Lordship 19/6/2026, Lordship.
okay, after that,
Yes, after that, Lordship. After that, Lordship, what happened? My complaint was recommended before the Interblaze Territorial Customary Court, which is the affiliate authority, Lordship. Now, on their recommendation, in fact, the Interblaze Territorial Customary Court issued summon also for Kaba, Parvana for Kaba also, Lordship.
Intervillage, which is,
Yes, appellate authority, because
okay.
he has received the recommendation from the HGB saying that this complaint cannot be taken under his chairmanship. So on the basis of that recommendation, Interblaze Territorial Customary Court issued Parvana, Lordship.
Where? 51?
Lordship, I'm coming to page number 47 onwards, Lordship.
No, this is complaint. Parvana is 51.
51, Lordship. And type out copy is 53, Lordship. Here also they clearly mentioned that we have received the recommendation from HGB of DC Blaze. So the Kaba will be conducted and fixed it on 8/6.
Okay. So when?
It was Kaba was fixed on 8/6, Lordship.
Okay. 8/6.
Yeah.
It was issued, the Parvana was issued on 27/5.
Yes, Lordship.
Or what, 8/6.
Parvana was issued. And then page 57 here, Lordship, 8/6 this time 10 a.m. Then page 54 here, the date of Kaba is shown, Lordship.
Okay.
Therefore, following HGB are hereby appointed as the judge members and requested to attend in scheduled date and time as under. Kaba was fixed on 8/6, Lordship. Then, Lordship, on that day, Kaba could not conduct it because the respondent did not appear. Now, Lordship, thereafter, again, page number 57, may I take it to page 57?
That copy at 58.
58. Here, Lordship, then another someone was, Parvana was issued from the same place, DC Blaze, who earlier forwarded, recommended my complaint to the Interblaze.
After
After
having recommended,
yes,
when the complaint was no longer with him,
yes,
he had issued Parvana.
yes, Lordship. Now they are saying that they
No,
received
they- So three court has decided your land dispute.
yes, Lordship. Lordship, by page 58, they made another new Kaba chairman, Lordship. And they issued this Parvana. Saying that some other complaint has also been received in respect of that disputed land.
Some other complaint.
Complaints from other intellectual members.
Okay, so this is not okay. But this is not on your complaint.
Yes, here also
Since your complaint has already been referred.
referred. But here, Lordship, in the same, this Parvana, the contents of my complaint is also mentioned, Lordship. May I just read this page, Lordship?
Yes.
Last evening, on 19/6/2026, the head Gawpura of DC Blaze, along with intellectual, PRI members, senior citizen, youth and elders of DC Blaze, filed a complaint regarding the Rockpo Blaze land matter. This is the same subject matter which is in dispute, under dispute between petitioner and the respondent family, Lordship.
Just a minute, PRI members,
Yes,
Gambura,
head Gawpura.
along with the PRI.
PRI members, intellectuals, PRI members, senior citizen, youth, and elders of DC Blaze.
So, receive a complaint for all of these.
Yes, Lord. Contents of this Kaba Parvana, Lord. Here, three points complaint. Complaint number 1, Whereas Sri Jummo Dirsi, the father of the present respondent, and his family had signed a document admitted that the rockfall land belongs to the Doi River petitioner. Now they are saying about that declaration deed lawsuit. And point number 2, roadside of the Dodo ground. And point number 3, Dodo ground. 3 points, the complaint they have received on these 3 points. And down below, Lordship, the contents of my complaint is also mentioning here, Lordship. And Sri
Your
Doi-
river.
yes, Doi River petitioner has also filed a complaint before the HGB. He's talking about that complaint, Lordship, which was already recommended. Yes, already recommended before the appellate authority.
Regarding the ground. Rather than coast service. Okay, now the Sikandirchi
Yes,
is, no, this time this is not Chikandirchi. This Dirchi, who is some other,
Sikandirsi is the HGB, Lordship, who recommended my.
but then this Parvana was issued by somebody else.
Yes, they made some other new Kava chairman, Lordship.
Now he is going to decide
Yes,
the complaint by all those members
Lordship,
of the village
yes,
and also the complaint by the petitioner
yes, Lord,
earlier, which has already been forwarded to the,
yes, Lordship, before
okay,
yes, appellate court, Inter-Village Territorial Customary Court.
conducted on
It is
19th.
pending there, Lordship, it's still pending there.
Okay,
Now, then next, Lordship, then immediately this Parvana was received by the petitioner on 15/6, though that has been mentioned as Lordship 10 June. And instantly the petitioner have filed reply to that Parvana, Lordship. May I take this page 59, next page, Lordship. On the same day, 15/6, and translated copy is 61, Lordship,
saying what?
saying that in the said Parvana, many complainants has been mentioned, but name of the complainant has not been provided to me, and the copy of complaint has not been provided to me. And of course, Lordship,
No, he stated that all these members
yes,
mentioned,
yes,
senior
mentioned,
citizen, PRI.
yes, Lordship.
So your claim is that the copy of the complaint was
Complaint,
not
Lordship.
furnished to you.
Yes, and also at the same time, Lordship, I made a fair that on 19 fixed date where Kava was fixed, I could not appear on 19 because I have received a copy on 15 only. In the last page 62, Lordship. 6 to last, therefore. Therefore, I request for serving a copy of Parvana. I request your customary court should conduct the proceedings in just and fair manner. I regret to inform you that I will not be able to attend the Kava scheduled for 19/6/26 at 9 a.m. due to my busy schedule fixed on this day.
Now, what is your prayer?
Now, Lordship, despite of serving this reply, they have conducted the Kava on 19 and they decided the Kava ex parte.
Which one?
That was 19, Lordship, 1960, impugned Kava decision, Lordship.
1906.
19, yes,
But this letter was written to the special resolution or the General Assembly.
General Assembly of the Siblings. This is the very, Lordship,
You addressed to whom?
forum I addressed to that new Kava chairman, Lordship,
Of the General Assembly,
Sentoriba, Lordship, who served the Parvana, Lordship,
Santo.
Sentoriba, new Kava chairman.
This was the first day fixed.
Yes, first they fixed, Lordship.
In your application, have you also informed that earlier you lodged complaint that was forwarded
Yes,
and
yes.
now you have received the summon? Where have you stated?
Lordship, Complaint respondents of
Page 61.
Yes, in page 61, I mentioned lots of the place which I submitting reply. No complaint has been submitted pertaining to the pendency of the case. However, two response has been submitted to the point number 1, 2, 3, there's another complaint and request. Point number 3. Then 62 lots. The statement in Wilfera for one mentioning that Sri Doi Riba has also filed a complaint report the head Gabura disciplines, to which I am submitting my reply as of now. The complaint regarding encroachment of Al Jumlan is not pertinent to any encroachment against the landowner, but relates to a complaint filed against the contractor of DC Rimi Road. That no cover was convened in this regard, that the said matter is presently pending before the Upper Court, and information regarding the same has already been furnished to
This is
the
in which para?
page 62, Farah number 2, Lordship.
Hmm.
Page 62, Lord. Where Lordship point number 1 is given, number 1.
Hmm.
The complaint regarding encroachment of Al Jumlan is not pertinent to any encroachment against the landowner, but relates to a complaint filed against the contractor of the DC Rimi Road, that no cover was convened in this regard, that the said matter is presently pending before the Upper Court, and information regarding the same has also been furnished to the AGB DC Blaze regarding Farwana issued by the Interblaze Court. That entire information already it was furnished to them also. In fact,
So, UFO,
I'm for the caveat respondent, malad the Jummo Dirsi
respondent.
malad. Jummo Dirsi malad. Malad,
hmm,
subject to the completion of the malad submissions made by my learned friend.
you, no. Your name is there?
I've not seen that malad, the basically
Respondent, there only one respondent,
Jummo.
Mohammed.
no. The respondent is the Momar Dirsi.
Momar Dirsi malad. Momar
Hmm.
Dirsi malad. Momar Dirsi,
Jummo is-
Momar is the son of Jummo Dirsi malad.
Mohammed is son of,
Yes, malad.
To my humble understanding,
Jummo.
Lordship, contempt is yet not registered, I think, because I
you
have
are
not.
Jummo,
No. Yes,
you are for Jummo,
Jummo.
not for Mohammed.
Malad, Momar Dirsi is the son of Jummo Dirsi malad.
Okay, so
Malad,
you have an independent claim.
no, malad. We are not claiming independently.
Okay,
This is the only fact where I brought to the just I want to brought to the notice of this honorable court. Malad, in olden days, malad, there was a community land which has been owned by the entire community, malad. Now this is a malad the land where malad all the villagers are malad using the village as community land, malad. And this resolution, which has been impugned by my friend in the present civil revision petition, malad, is malad the resolution of the village, malad, special resolutions of the General Assembly of the DC village, malad. Malad, admittedly, to my understanding, malad, this resolution is just more than malad the malad the village authority, malad. This consists of the entire village, malad, the members of the
so if the people of Arunachal comes, it is more than High Court.
Malad, what I'm suggesting is, malad, what I'm submitting is,
Hmm.
it is voice of the malad, the villagers.
Okay, so that can be done.
Yes, malad.
How?
That can be done, malad, as because this is not a completely the individual ownership, as
Okay,
because
the,
everybody has,
complaint file, complaint is pending before the village authority.
malad, exactly, malad, that is there, malad. But then, malad, my,
So that means the community, the village can disregard the village authority or the court.
malad, that part, that is the contention, whole contentions of the malad, the parties, that this piece of land belongs to the village community within malad, the community
Please
land.
yourself before the village authority.
Malad, may kindly appreciate one thing.
Huh.
Entire area is a village land. And in
So that's
some
why I'm saying,
community land,
Hmm.
in community land, they are fighting each other, my lord. Within the community lane,
Hmm.
my lord, this, if lordship used, my lord,
Now the community can lodge before the,
exactly, my lord,
Village
therefore the
authority,
community has
this
just to avoid-
community combined, they can lodge complaint before the village authority.
my lord,
They are the encroacher, both the individuals fighting each other are the encroacher
yes, my lord.
upon the
Not
community
exactly
land.
the malad, the encroacher, malad, may I, the malad highlights the facts of the case, malad.
So you represent whom now, tell?
Malad,
You said you are father of the
Mohammad
respondent.
Dirsi, malad.
Hmm?
Mohammad Dirsi, malad. Still not
But-
sure, okay. Malad, I'm
You're not for the community.
not for the community now, malad. Malad, this decision has been taken.
What is the difference or the claim, separate claim between this father and the son?
Son, malad, if per use,
interest.
malad, the other, malad, there is a other, malad, the other letter issued by the malad, the father and the other party. Malad, I have not gone through the malad, exactly the copy of the civil revision petition, malad. Malad, my contention is,
No, you said that you filed caveat,
yes, malad.
whether the decision is in your favor.
Decision is in favor of entire community where my float is also there, malad. Where the present land dispute is, malad, may I take your lordships to them, malad, particularly, malad, this decision has been covered. Malad, the village authority is covered by the, malad, may I take your lordships to? I have not seen the copy of the malad civil revision petition, malad, special, just for a moment, malad, special resolution of the General Assembly of Dishi Village, Leparada, taken on, malad, the 19/6/2000.
So that this decision, decision of assembly, General Assembly is in your favor or against you?
It is in my favor, malad. This
Okay.
decision is in my favor, malad. Therefore, malad, may I take your lordships to first, just pass.
So you are among the villagers.
Yes, malad.
What,
Malad, I am,
that means,
malad, this
are
is,
you representing the entire village?
yes, malad. This is a area, malad.
You authorized.
Malad, this is a area
Hmm.
where petitioner is also residing, where I'm also residing. And it is part of that, malad, the community lane where we are residing, malad. The basic contentions of the petitioner is, this is my individual lane. So therefore, on my individual lane, you cannot encroach. This is the subject matter of the allegation which is pending before the, malad, the appropriate, malad, the village authorities. Now, malad, the entire villagers have taken a decision that this land belongs to the community. It is neither individually owned by you nor owned by the other party, malad. Now, the malad, if lordship peruse the malad, the decisions of the village authority, malad, this so-called assembly, malad, wherein it has been Rokpo Kode declare community land of the Dishi village. This, malad, the Dishi village is consist of several pockets like, malad, the Aya village and malad, place called Aya and place called, malad, the Rokpo, place called, malad, the another place. It is called Dodo, madam. Dodo community land.
Is it a proper way, just tell? Is it a proper way? Because the case is there
Malad, this
pending,
declaration, malad,
pending complaint between the two individuals over the over the plot of land
malad, that
is pending before the
exactly,
village
exactly,
authority.
malad.
So
Exactly, ma'am.
if the community think that this land belongs to the community,
Malad.
why don't the community
Malad.
lodge complaint against these two individuals
Yes.
instead of declaring themselves?
Yes, malad. Malad, exactly, malad. This is one, malad, it is-
On the basis of this declaration, you can file a complaint
malad,
against
this
this board.
this declaration
individual.
is not simply Sita, malad. Exactly, malad. What I'm pointing is, exactly, malad. Lordship has, malad, correctly observed. This is not the simply Sita's, malad, the decision of the village, all the village, malad. This, as I have pointed out, malad, the village land, malad, the place where the dispute is going on is part of the community land called Rokpo, malad. There are 3 pockets of land. One is Aya, second is Rokpo, where we are residing, and the third is Dodo, malad. Malad, this decision is in respect of entire
Yeah,
village.
that is why I'm saying this entire land belongs to the community.
Yes, malad.
Okay, agreed.
Yes,
Okay, agreed.
yes, malad.
Okay, but in this village, in the community land,
Yes, malad.
two individuals
Correct,
are
ma'am.
fighting over a small plot of land,
Yes, madam.
okay?
Yes, madam.
So-
Exactly, madam. Exactly, madam.
Undermining that the main owner is the community land.
Madam.
But then the community actually owns this land. Why don't the community file complaint against these two individual, I'm saying, so that it is decided in the name, in favor of the community?
Exactly, my lord. That will be
So,
adjudicated by the
instead-
village authority, which is still pending, my lord. My respectful submission, exactly, my lord. What I wanted to make submission is exactly the observation following from your lordship.
Hmm.
That is the subject matter, my lord.
Hmm.
That will be adjudicated, that will be decided by the village authority, which is still pending before the, my
Yes,
lord,
yes,
appropriate
yes.
authority, my lord.
Hmm.
So, my lord, what I want is, my lord, today, my lord, no interim is because the matter is already sub judice before the, my lord, right or wrong, it is pending before the village authorities, my lord. But
Yeah.
this decision, my lord, decision is in respect of the entire village, not only for the respect of, in respect of Rockford, my lord, Kode, my lord, Rockford land, my lord. So therefore, this may, my lord, what I am submitting is,
Hmm.
lordship may, my lord, if lordship interferes with this special decision, this will affect to the, my lord, the entire other villagers also, my lord, and the villages also. My lord. So therefore, the subject matter is very small, my lord, the only small piece of land where they are residing, my lord. Their claim is, no, you are encroaching my land. And the another party is, no, this is the community land. This is not the question of encroachment. We are right to settle therein. Malad, therefore, malad, that part, malad, that will be adjudicated by the, malad, the village authority, malad. As my Ladet friend has also demonstrated that, malad, that is already pending before the village authority, malad, that will be adjudicated, malad. So therefore, malad, at this stage, malad, malad,
Where is the decision affecting your plot of land under dispute or which is pending before the village authority?
That is Rockford land, lordship.
Rockfall and but which sentence of
Page
the
60
declaration?
65, lordship. Rockford Code declaration, community land of
Malad.
the
This is the exact
Page
document
65.
that I just wanted to show you, lordship. Malad, this is not only the in respect of his malad part of land, malad. This is entire land.
Rockford
His
Code
case is
declared.
also given, malad. Malad, Rockford Code declared community land of the DC village, malad. May I read, malad? The village
Mhm.
assembly unanimously declares and affirms that the land known as Rockford Code, malad, where we both are residing, malad, and the Code forms part of the community land of the DC village, malad. The land has been traditionally recognized, occupied and protected and maintained and used by the village community from the time immemorial, my lord, and shall continue to remain community land, governed by the customary laws, the practices and the resolutions of the village assembly, my lord. Otherwise, my lord, this is not going to affect him also, my lord. He is peacefully residing there, my
What
lord.
is your notice?
Lordship, what my senior is trying to project, this decision is assembly, lordship, this decision is the outcome of that Farwana issued by the Kaba chairman. This is a Kaba decision, lordship. And lordship aware that as per AFR and APCC.
No,
Arunachal Pradesh
whether-
Civil Court Act,
No, this outcome of
Farwana,
Farwana?
lordship. Farwana. issued by
Parvana
the-
was issued by some other authority again,
Yes,
not by this authority.
not by this authority.
So this is not connected with those Parvana.
No, lordship, he was the Kaba chairman, lordship.
Who?
He himself, who issued the Parvana, lordship? That
No, no.
Santo River, lordship.
This resolution of the General Assembly, this order,
Exactly, ma'am.
General Assembly order.
Yes. This was passed ex parte under the chairmanship of Santo River, who issued the Parvana by fixing a Kaba on 1906, lordship.
1906.
Yeah. Yes, lordship.
Then it is connected.
Yes, connected, lordship.
Parvana, if the Parvana was issued to conduct Kaba
Yeah,
on
On
1906.
1906, lordship.
But then this decision is not by the Kaba, not Kaba again.
Yes, madam.
This is the special resolution, not the Kaba decision again.
No, himself was the chairman of that resolution.
But he did not sign it or pass this order or
As an individual, madam.
took this resolution,
Altogether signatories of-
resolution in the capacity of the village authority or the Kaba.
Lordship. Now,
This is
lordship,
different authority.
may I take you,
One person can be
Executive.
act
may,
act in a different authority.
may I take you page 66, last ending of this resolution for
Yes.
lordship. 66.
Hmm.
Now, just above the table, lordship.
Hmm.
Accordingly, the matter is then disposed of by the Blaze Assembly. Now that Farvana has been disposed of,
According to the
including my
matter
complaint,
stands disposed
I
of.
was not heard, lordship.
See, they have mixed up everything.
Yes, lordship, lordship. That's why
It's difficult to separate
Yes,
also.
yes, lordship.
He has, see, the authority is the special resolution is called General Assembly. But then General Assembly has disposed of the
Yes, that complaint of.
Kebas Parvana.
Yes, Kabas Parvana. That is my contention, lordship.
Everyone is seizing the power of each other.
Yes, lordship. They are acted, they conferred themselves as the power
Now-
of civil court
Hmm.
by agreement of this party, lordship. They constituted Blaze
Now-
Assembly,
now-
discharging the power and functions of civil court, which is not permissible, lordship.
So now an advocate is saying that if the entire village decide, it will,
No, Lord.
the district judge will
No,
have no
that-
power.
That's,
No,
that's,
That is in respect
Now,
of, my lord, the
entire Blaze now.
land belongs to community, my lord.
Lordship, they have decided the title of the disputed land, lordship,
Anyway,
which is
well, issue notice. The
which is
cabinet has
pending
also
before the
come.
lordship
Cabinet discharge.
court,
huh?
lordship.
Mr. I'm Kato. But
Caveat, lordship, I am also not aware the caveat
you are for,
whom, yes,
The-
represent.
not for the respondent, but the General Assembly resolution,
Who is the lordship? This is the problem.
cabinet is filed on whose behalf?
Jummo Dirchi, my lord.
Jumo Dirchi
Yes, my lord.
represent the,
Jummo is not before your lordship.
Jummo is the father of the, my lord, the,
no, by virtue of being father, he doesn't acquire right.
Yes, right, exactly.
But then, if you are representing the special resolution, General Assembly, otherwise the party is Doi.
Yes, petitioner.
petitioner is the Doi.
Doi's
Doi.
father is not Jummo again, Nyado.
My lord, Jummo Dirchi is the, my lord, the original respondent in the title suit
Okay,
between the.
Jummo is the father of Momar,
Yes, my lord. As I
Momar.
put it, yes,
but then the party is Momar only,
Yes,
not Jummo.
exactly, Lord.
You are representing the respondent, sole respondent.
yes, my
Or
lord.
No, no.
then Momar has to authorize you.
Petitioner, Jummo no party mo.
Who are the party in before the,
Doi Riba is the
Keba?
petitioner and Momar Dirchi is the respondent here, lordship.
in the,
But the caveator is some
in
other-
the Keba also?
Yeah.
In the Keba, who is the complainant? Then who is the respondent?
complainant, they are only mentioning that lordship, 8 GB, all intellectual,
No,
PRI
no.
members.
No,
Yes, in my
in your
complaint,
complaint, in
yes,
your
I
complaint,
lost the complaint against the Momar, present.
against
respondent.
Momar only,
Yes, lordship,
not Jummo.
not Jummo, lordship,
Okay,
because, yes,
but then you said that the settlement was with Jummo.
earlier declaration was done by, that's why,
Hmm.
we have no issue on
Yeah.
that earlier complaint, lordship.
You empowered him earlier because the case was with Jummo. You decided with, case was with Momar, but you decided with Jummo again.
No, lordship, no, lordship. Lordship, my first initial that complaint was against the Jummo father. Accordingly, they enter into a declaration declaring that yes, land belong to the petitioner.
Okay,
Accordingly, that complaint was.
okay, now the
withdrawn.
encroacher is Momar.
Yes, now, after the deed of declaration
Hmm.
entered by his father,
Hmm.
now son is started encroaching upon my land. That's why I filed a fresh complaint
Hmm.
against the Momar.
So now you have to, you tell who are you?
My lord, as per the caveat, my lord, the caveat filed by me, my lord, it's
Hmm.
for the Jummo Dirchi, my lord. Son
Jummo.
of- He's
No,
the father of the,
Jummo is only father.
yes, lord, father
of
of
the
the Momar
respondent.
Dirchi, my lord. So subject matter.
So
is
he
bet-
has no grievance against Jummo.
No, my lord. Subject matter is basically between me and the Doi Riba, my lord, the petitioner, my lord. In some, my lord, the person,
No,
somewhere it has
Because
been derailing.
your dispute has already been settled earlier. But then here is a new cause of action arose when when Momer encroach, and the complaint is against Momer only, not Jummo.
Malad, as I pointed out,
Momer is major, independent, and capable of encroaching, take care of himself. Jummo is father, has become old, I think.
Malad, may kindly peruse my, Malad, the caveat petition, page number 9,
Mhm.
my caveat petition, Malad. Page, it starts from page number 8, Malad.
Page 8,
Yes, Malad.
what is that? This.
Malad, may I take your lordship?
This is resolution only.
Yes, Malad. In the resolution, Malad, it has been reflected, Malad, my, the entire, the Malad, the facts, Malad. Para 6, Malad. Page number 8, para 6 of my caveat petition, Malad.
Page
During the
number,
process
page number
of
8,
Malad,
para 6.
para 6, Malad.
Okay.
During the course of the proceedings, the Sri Jummo Dirsi and Jummom Dirsi and other members of the Dirsi family appeared and admitted that they have executed and facilitated the declarations deed in the favor of Sri Doiru without, Malad, this is important, Malad, without obtaining the consent. So basically, my lord, this is going to affect my rights, my titles. So therefore, my lord, I am the caveat, my lord. And the consent approval and or authorized by the village community, my lord.
No, that means
Village-
you are you agree by this?
Yes, declare it.
No, just a minute. Are you agree by this?
No, my lord. I have not agreed by, as because my lord, I have already pointed out.
They have just mentioned that
My lord, it is in
you
respect of
declared.
my lord, dispute pending before the village authorities, my lord. As I have pointed out. And my lord, page number 9, my lord.
It only refer that
Yes, my lord.
you declared in favor of Doi.
My lord, that part, I have already, my lord, initiated that declaration has been, my lord, is subject matter of the, my lord, the adjudication before the
See,
village
see,
authority.
you already declared in favor of Doi Riba, isn't it?
Which I cannot, madam. Which I cannot. This is a village authority, village land, as I have pointed out.
Now, are you withdrawing? Have you applied for the declaration?
My lord, I'm sorry, my lord, I have not that the information, my lord. The page number, my lord, 9, my lord. Just
Then in that case, you see, if you are withdrawing, there is a different,
my lord, to that extent, I haven't any information
different
about that
authority.
part, my
You
lord.
have to approach.
So far, I have
proper
no any
authority.
instruction, my lord. So far, I have no instruction on that point, my lord. My lord, page number 9, my lord. My lord, may kindly
No, probably.
kindly see page number 9, my lord.
Hmm.
Page number 9, my lord. Final declarations of the jury of the village assembly, my lord. After careful considerations of the informations, the oral testimonies, the admissions made by the Jummo Dirsi, my lord, the cabinet and his family members, the village resolutions of the 2023, the customary laws and the practices of the Gala community, the executive order dated so and so, issued by the Deputy Commissioner, West Siang District, the resolutions of the Basar Bango Gaugura, the meetings are held dated so and so, so and so. Principles of the Bagumboka Gala customary law, and the long-standing recognitions of the Rokpo Kode as community land, and the Malada Rokpo Malad. This is the exact Malad where we are residing, Malad.
This is what he is aggrieved.
Malad.
So he has challenged this.
Yes, Malad.
You
Now,
are agree by what?
Malad, agree by the Malad that this village decision, Malad, the assembly decision, Malad.
You are agree by assembly.
No,
decision.
no. Malad, petitioner, Malad.
Huh?
Petitioner, Malad.
Petitioner?
Yes, Malad. And Malad, declaration, Malad. Just for a moment, Malad. Declaration A. Malad, declaration A, kindly. Malad, declaration A, same
have to-
same caveat,
No, you
page
have
number 9.
Clarify your stand. Declaration, you are agree by this declaration.
Malad, I am, this declaration is neither affecting the other party nor affecting me, Malad. As because this land is a community land, this is for community purpose, this has been decided. Malad, if this is,
So you are representing the community now. It appears.
Malad, if this decision is interfered with by this honorable court, Malad, the present dispute between the Malad, the petitioners before the village authority will be ultimately
You,
affected.
you,
my lord.
no, you are not with dispute with the petitioner in any, before any other court now. Your son is in dispute because he has encroached. He is trying to claim a lane, a plot of land, which ultimately it appears belongs to the community. And in this land, your son encroached. That dispute is there. Ultimately, later on, of course, whose land this actually belongs to will be decided. But then as of now, the dispute is with the petitioner and your son.
My lord,
And then the petitioner is also aggrieved by this declaration.
my lord.
You are not aggrieved, I think.
My lord, that part, my lord, I need to take instruction. My
Yes, yes.
However,
It
my
will be
lord,
better.
ultimately it is going to
Better,
affect,
you get it implemented later on if you find that, no, you will be affected.
my lord.
You file an implement petition, proper implement petition.
Yes, lord.
Now, as of now, so what we'll do, we'll issue notice for the time being.
Yes.
Okay.
And lordship, yes, I have interim prayer because by that impugn ex parte,
Just let us see, huh?
lordship.
Let us see. Had Mr. K. Lole, Ghana counsel for the petitioner. Okay. This, the present petition, huh? The present petition is direct, under Article 227 of the Constitution of India is directed against the where is the recommendation?
Recommendation, lordship.
The,
Page 35, lordship.
okay, recommendation dated 22/5/2026.
Page 35, lordship.
Of his complaint. Recommendation dated 22/5/2026 made by, and of his complaint by the head GBDC, DISI, huh? DC village, huh? Head GBDC village. No, recommendation dated 22/5/2025, 26,
26.
whereby the head GBDC village recommended his
Yes, complaint,
complaint
yes.
to the
District customary
where
trial.
is, hmm?
District
Where do we find in the recommendation letter, where?
35, last,
No,
down below, lordship.
35 is there, down below.
Yes,
District customer, okay.
yes.
To, whereby the HGBDC village has referred his complaint to, recommended, his complaint to the district customary trial court, Basar, for further, for decision.
Yes, lordship.
Okay, and the decision dated 19/6/2026, whereby by which the special,
General Assembly, lordship.
so by which the General Assembly of
Yeah.
DC village by a special resolution. It's a special resolution
Yes,
has decided the disputed land
Yes. Disputed rockfall and,
namely Rockport Coded
yeah,
Code
yes, Kode means landlords. Rockfall land.
land as the community land of DC village.
Yes,
Stop, huh? It is submitted that, I think one, so rest, I'll pass order.
Lordship.
Hmm. Just a minute then, huh? Take, huh? It is submitted that the his complaint, sorry, just a minute, huh? The land earlier was declared, and the land earlier disputed by Jumo Dirchi was declared
It is private and ancestral land of petitioner.
as his private and ancestral land. However, the respondent tried to encroach leading to filing of complaint against him, and the case is pending before the Intervillage Territorial Customary Court,
Basar.
Basar.
Yes.
Stop, huh? It is further submitted that the General Assembly of DC village does not have any jurisdiction or authority to decide the matter. Stop, huh? Para, issue notice returnable by 4 weeks. Stop, huh? The petitioner shall take steps for service of notice upon the respondent by a speed post as well as by usual process within a week from today. Stop, huh? Para, list this matter after 4 weeks. Stop, huh? In the meantime, the operation of the
Malah next date maybe malah kept open for malah the interim period malah.
yes, order dated 19/6/2026 in respect of the petitioner's disputed land shall remain state. However, however, the party shall maintain status quo
Well-
over the land as of now, as on today.
Malah,
Okay,
Lordship has already observed na in respect of malah that
in respect of only,
Yeah,
because
disputed between the. yeah.
entire matter we
No,
cannot,
no,
cannot.
Lord,
Hmm.
Lord, rightly observed, Lords. Petitioner also not claiming entire place land, Lords.
deeply applied.
Deeply obliged. Lords.
Item number 2,
Yes,
Your Lordship, this is a civil revision which I file against the order dated 15/6/2026, whereby my 3 interlocutory application was rejected with by common orders.
your application,
Yes,
what application?
my application for dismissal of the appeal, because appeal was filed without a condonation of delay applications, which is a mandatory requirement
Okay,
under CPC and also under the Assam Frontier Regulations. Section 51 of the Assam Frontier Regulations says,
it was filed before the deputy
yes,
commissioner.
it was filed before the Deputy Commissioner in the year 2015.
There was no mention in the appeal also regarding condonation of delay.
Yes,
Or only the separate application was not filed.
separate applications was not filed.
But in the appeal, was it mentioned?
No, it was not mentioned.
Okay, so there was delay
There was delay.
and your application was for rejection of the
Appeal,
appeal. That has been rejected.
yes, that appeal should be rejected because they had not filed condemnation application.
But your
on the-
application has been rejected now.
Yes, my application was rejected
Okay.
because after 11 years,
Mhm.
now they says that the condemnation can be filed at any stage, but that is only before the issuance of the
When this
certificate.
appeal was filed?
Appeal was filed in 2018 December 2015.
Some
An
11
order
years
was,
back. Some
yes.
11 years back.
some 11 years back. An
Okay,
impugn
you
order.
filed
was-
application when? When did you file application?
No, this was pending before the deputy commissioners.
Okay,
And after the Arunachal Pradesh Civil Court Act came into force,
when it was transferred?
it,
In a deputy commissioner court, have you contested?
no notice was issued
No
to
notice
us.
was also issued.
Yes,
But, okay, after,
after the case get
It was
transferred to the civil,
now you file
civil
IA for,
senior divisions,
hmm,
appeal was admitted. Then only notice was issued to me as a respondent to appear before the court and
okay,
to file reply. So we learned about the appeal then we filed an application
hmm.
to dismissal of the appeal because
When it was filed?
it was filed on December 2025. After notice was issued to me
Okay,
to appear in the appeal.
hmm,
Then I filed it since there is no condonation applications, so it has to be rejected, which is a mandatory
will issue
requirement.
notice?
Yes, Your Honor.
Mr. D.K. Deori, land counsel for the petitioner. Hmm. This petition under section 115 of the CP Civil Procedure Code 1908 challenges the common order dated 15/6/2026 passed by the Court of Civil Judge Senior Division Teju in title appeal number 02/2025, whereby the
Interlocutory applications number 30, 31, 32, 33 was rejected.
this was passed in appeal,
Yes,
title appeal only.
title
No, your rejection was passed in your IA.
IA.
You said, where is that?
This IA is Annexes 1, Your Honor. Or orders in Annexure 1 in page 14, starts with page 14.
Hmm?
Interlocutory applications number this for dismissal of appeal filed against the Kevang decisions dated demand.
No, but then it appears that this impugn order disposing or rejection
Yes,
is in title
rejection
appeal
is-
number 2 only. Title appeal number 2 only. it
Two.
appears.
This interlocutory application are filed in title appeal number 02. But
Okay,
here,
so where is
order was passed here 02, but in the order this mentioned it as IA number this
Okay, IA number where?
30.
So IA number has not been mentioned.
Yes, in
in-
the cost title, it is not mentioned, but in the
Course that
body part of the
it
order,
is
it
not
is-
mentioned. Hmm?
body part, it is mentioned, Your Honor. It's page 14. The first paragraph, the
Page?
applicant. Page 14,
14.
yes.
Is title,
No. Applications have filed interlocutory application number this.
okay. But then this disposal should have been in the interlocutory
Yes,
application.
it has to be separately, order should have been
Hmm.
passed separately.
But instead it was passed in the title appeal only.
Yes.
No, so some difficulties because it says that the above instant application is rejected. That means this title appeal is rejected, it appears.
No, no, my applications, these four.
No, see, the title, page 14, you see, this is title appeal only.
This is
The order was passed in title appeal.
title appeal, but rejecting my applications. Because para number 1, Your Honor, may I read? The application has filed interlocutory applications.
But, okay, this is,
This filing, and para number 10, Your Honor, it's in, if we continue to in the judgment, it says the application file is rejected.
Hmm. So this sounds like
In-
the appeal has been rejected, isn't it?
Yes, it seems like that, but in view of the above, the instant application is rejected.
Hmm.
Not the title appeal, but my applications are rejected. And with the directions to the appellant to rectify the appeal
Hmm.
with a condonation application as required under Order 41, Sub-Rule or Rule 3A of CPC. The last part, internal page 6 of the judgment here.
Page 19. Page,
Yes, sir. Repeat. Page. Just a minute.
and the appeal,
19, yes, 19.
uh,
Para 10. In view
appeal
of
has
the-
been returned to the appellant
Yes,
for allowing him to file consolidated appeal under order
along with the condonation.
Roman 41, Rule 3 CPC, along with the condonation application. Okay, stop. It is submitted that. The learned civil judge, senior division,
Senior division.
has passed the above impugn order allowing,
Not, they had rejected my applications, but they allowed the appellant to file.
no, rejection. Rejection is okay, but then allowing, you agree by.
Yes.
Allowing the appellant to cure the defect
Defects.
and directed to file consolidated appeal under order Roman 41, Rule 3 CPC, along with the condonation application, has exceeded the jurisdiction.
Yes.
Okay, stop. Issue notice. How many respondents are there?
2.
Okay. The petitioner shall take steps for service of notice upon the respondents by a speed post as well as by usual process within a week from today. Stop. Call for the record. Scan copy of the record. We'll call for the scan.
Scan copy.
Okay, stop. List this matter after receipt of the
Court
record. Okay,
Your Honor, another application.
at least a matter after 4 weeks. What is that?
That is for the stay of the order
Okay,
till disposal of this revision petition.
same, hard, huh? Mr. Deori, line counsel for the applicant? Appellant, no, applicant, stop, para.
Petitioner.
By filing this application under order 41, Rule 5 of the Code of Civil Procedure 1908, the applicant seek a praise for stay of the order dated 15/6/2026 passed by the Learned Court of Civil Justice Senior Division, Teju, in title appeal number 2, 2025, whereby the while rejecting the interlocutory application, where is the number interlocutory
30.
application?
It's page 14, Your Honor. 30,
14.
31, 32, 33.
While rejecting in the page 14,
14.
okay, interlocutory application filed by the present applicant stroke respondent, for rejection of the appeal on the ground of not on the ground that the appeal filed by the respondent stroke present appellant stroke present respondent, the respondent in the state case was not accompanied by the condemnation application, comma, the Learned Civil Justice Senior Division has allowed the appellant stroke present respondent to, where was that direction? Allowing him to file. Where is the impugn orders? Last part.
Last part. It's page 20.
Has returned the appeal with the direction to file a consolidated appeal under appeal within bracket order 41 rule 3 CPC along with the condemnation application. Stop para. Issue notice to the respondent, staff. The applicant shall take steps for service of notice upon the respondent within by speed post as well as by usual process within a week from today. Staff. In the meantime, the operation of the impugn judgment and the impugn order dated 15/6/2026 shall remain state till the next date of the next returnable date. Okay.
Obliged.
Item number 3,
Please, Your Lordship.
Yes.
Lordship, this criminal petition is directed against the for criminal complaint case pending before the London CGM, Teju.
Okay. Where is the
Lordship, in this,
this is a joint petition or
no, Lordship.
okay contest?
The CR case, Lordship will find it page 74. Starting from page-
74?
Yes, page 74. I'm seeking quashing of this particular complaint case.
It's a complaint case.
Correct, Lordship. Now, this complaint case has been filed under Negotiable Instrument Act,
Okay.
alleging that the check which was given to the complainant has bounced. Now, Lordship, here what we have to see is, Lordship, the check which was given in lieu of the debt, whether that is enforceable debt or not, Lordship. Now, here it is very apparent from the records that there was non-existence of any enforceable debt. Now, Lordship may kindly,
Whether the
before issuance of that check,
Hmm.
which got bounced, Lordship, whether
before issuance,
issuance of the check, Lordship, we
no,
have
no,
to
check
see
was issued.
check
or
was
not.
issued.
How it is before issuance?
Lordship, yes, Lordship. What we have to see is, before issuance of the check, we have to see that whether there was a enforceable debt or not, for
Okay.
which that check was issued.
Okay,
Now, here in this case, Lordship, we'll find that there was no enforceable debt.
why it was issued then?
Lordship, the check was issued under coercion. Lordship, I'll demonstrate with the material available in this.
Thereafter, have you informed or lodged complaint?
Yes, FIR is there, Lordship. FIR is
Just
there,
immediately after issuance of the check,
Lordship. That FIR is there, Lordship. And
when the check was.
it has been
issued?
registered also.
When the check was issued?
Lordship, Lordship will see the check at page number 49,
49,
49.
yes.
This is the check, Lordship. Will see
This was issued on
15/2/2026. Lordship.
15/2.
Date already, this check was given in the form of security, Lordship.
Hmm?
On the basis of a promissory note, Lordship, will find it in the earlier page, page number 48. This is the promissory note, Lordship. Lordship, before understanding all those, Lordship, Lordship, we need to understand the brief fact of the case, Lordship, what had happened, Lordship, okay?
Okay.
How this promissory note came into being, Lordship.
Mm-hmm.
Now, Lordship, Lordship, in the year 2018, Lordship may kindly come to page 32.
32. Okay.
Page 32, Lordship. This committee was formed, Lordship, through these minutes of the meeting, Lordship. Now, this committee was constituted for pursuing adequate compensation for lane as well as standing crop before the authority concerned, which was acquired for construction of 2-lane road from Wak Road to Meadow. This was the minutes of the meeting. A committee was constituted. Lordship will kindly see at page 35. One committee was constituted during the year 2018. Through this committee, the complainant,
Mhm.
he was made as the chairman. Lordship will see in the top, serial number 1.
Mm.
He is the complainant in the complaint case pending before the CGM, Lordship.
Complainant.
Yes, serial number 1. Solemso Ama is former Miss Student Union president. He was made as the chairman
Mm.
of that particular committee.
Mm.
Now, Lordship will kindly see before that page 34, Lordship.
Mm.
The purpose of constituting that committee is very much there in this particular paragraph of that minutes of the meeting, Lordship.
Mm.
Last second paragraph, page 34, type of copy is this. This is the minutes of the meeting. The House present unanimously decided that being the inhabitant and strategic state of the Arunachal Pradesh, welcome the road communication project by considering all the aspects, but landowners' right cannot be denied and neglected. Therefore, the House has formed a central committee under the nomenclature of National Highway Project Affected Families of Wakro Circle, with its 3 subcommittees. These subcommittees will act as they discharge their duties as directed by the central committee or after prior approval and consent from the central committee. At the end, before conclusion of the meeting, the House unanimously selected central committee and subcommittee as follows. Lordship has seen the central committee, legal advisors, subcommittees, 3 subcommittees were formed accordingly to look after and to buttress their rights before the authority concerned for payment of adequate compensation in regards to 2-lane project that was coming up at that point of time. Lordship. Now that the complainant was made as the chairman of that particular committee that was constituted in the year 2018. Lordship may kindly come to page 37.
Mm.
This was duly intimated to the Deputy Commissioner also regarding that formation of that committee.
Mm.
Page 38. There was a gave 2018, this is 2025. That anticipated that project which was going to come up, that never took place. But during the year 26 March 2025, notification accordingly came into being, Lordship.
This notice.
Notice for acquisition under
Hmm.
section 21 of Lara Act 2013,
Hmm.
Lordship. That came into being, Lordship.
Hmm.
Now, accordingly, Lordship will see page 40. This circular was issued
Yes. What is this circular for?
regarding the assessment that was being conducted, Lordship. Assessment was conducted and they prepared the authority concerned they, after the notification which I have shown, Lordship. It's page 34. Accordingly, the assessment was done. And then accordingly, they started to prepare the award for giving the compensation that was to be given to the beneficiaries. And certain discrepancies were arising at that point of time.
Hmm.
Accordingly, this circulars was brought in. And since that project was being executed by NHIDCL,
Hmm.
Lordship will see at Annexure 5 for page 41.
Hmm.
They had certain objection in regards to the draft of the award. So certain objection was raised.
Hmm.
And it was accordingly ratified. It was addressed to the Deputy Commissioner. Lordship will see that.
What is this, page 41?
Page 41 is the letter addressed to the Deputy Commissioner by NHIDCL, who is the executing agency of that particular road.
Hmm.
They had certain, who had to deposit the amount.
Hmm.
They had certain objection in regards to certain awards that was passed against the beneficiaries. So the debt was accordingly ratified, Lordship. Lordship will see at page 47, Annexure 6. Another circulars was brought in,
Hmm.
whereby those ratification was accordingly done. Now here, Lordship, the complainant, who is the chairman, who was appointed as the chairman at that point of time, he came up with this promissory note, Lordship, page 48, by misleading the beneficiaries, saying that if you don't enter this promissory note, if they don't come up with blank check, which is at page 49,
This
their
is,
compensation won't be paid. So under coercion, under misleading the beneficiaries,
who is this? The one who signed is?
is the suppressor pool. She's the applicant here in this case, Lordship.
No, what was she then?
She is one of the beneficiaries of that particular project.
Why she had to sign this?
Lordship, he was coerced and he was misled, saying that if you don't pay 10% of the compensation amount to him, that compensation amount will never be released.
Hmm. If, just a minute, huh?
So they were compelled to enter into this promissory note.
So who is she otherwise? She is only the beneficiary.
Beneficiaries.
How much she was to get
Lordship, amount we cannot
as per the draft?
award, Lordship. Now this 43 lakhs is the 10% of that award amount,
8%,
10%.
10% of the award that she was supposed to receive.
Gate, yes.
So she is to, so the complainant demanded this much amount as what?
Age, Lordship will see in the CR case, Lordship. Now they say that this amount was sought from page 76, Lordship. In their complaint,
No, this promissory note. was
brokerage
signed-
charge,
Hmm?
brokerage charge.
Okay, that is why.
That is very clear from their complaint.
Okay. She has.
Now they are saying that it is for the brokerage charge, but at that point of time, when this particular
Let us
promissory,
read again what it says exactly in the promissory note. Do hereby. in that sense.
do
Okay, in that-
hereby acknowledge myself to be indebted to Mr. So and so, and Mr. Modanso Tang, who is the General Secretary, Lordship. Solemso is the chairman of that committee. Modanso Tang is the General Secretary, Lordship. Make any note. Under the workflow circle in the sum of rupees, only for value received, I hereby undertake and promise to pay the said amount to Mr. Solemso Ama and Modanso Tang in check wide number so and so on their demand.
okay, so.
Now
no-
it is very clear from the,
No, no reason, no ground for what purpose?
yes. But
Okay,
then from their complaint case,
Hmm.
it becomes very clear that this
Okay.
particular amount was demanded for brokerage, as a
So,
brokerage charge.
This is not post dated also. This was the promissory note 18,
2025, post dated,
2025.
Lordship.
Okay, so this is as a post dated check that
Yes, it is a post dated check.
15/2. So it was expected that by then she will receive.
They say that by that time I have received the compensation amount.
4 to 3 lakhs. Okay, so then where is the complaint you wanted to show?
Yes, Lordship. Page 76, Lordship. Paragraph 4.
The one which shows I will. look at the first and look at what- For the purpose of that.
Paragraph talks, here talks about the formation of that particular committee. Now here Lordship has to note one thing, Lordship. That committee minutes of the meeting, which I have read it out, that relevant paragraph, which I have read it out. It never authorized the chairman to charge this kind of fees, Lordship.
It is only the chairman who charged.
He and then the general secretary.
Okay.
And general secretary also, after
This
coming to know,
particular check was that this post-dated check has been signed in favor of the complainant only.
and one more person, Lordship.
Just a minute. This is in favor of.
It's a blank check, Lordship.
It's
Name is not also not there.
not there.
Check, your Lordship will see. Later they have, maybe they have put my name and get it, put his name and the check was accordingly bounced, Lordship.
Okay.
Initially, it was blank check, Lordship. Post dated check. Now, from their CR case, Lordship, paragraph, relevant paragraph would be at page 78.
What happened thereafter? Whether the petitioner has received the compensation amount?
Yes. It was directly debited to my account, Lordship.
Okay.
It is a welfare fund, Lordship, that I get it for the land they acquire. The land that is acquired by the authority concerned.
Okay, so you received the compensation amount before 22 April, February.
They say that that amount was disbursed and sanctioned on 18th February 2026, Lordship.
Okay, when then the complainant or the respondent presented the check before the bank?
15 February 2026, Lordship. Page 78.
What is this promissory note? It's not of one, so many.
Lordship, similar way, Lordship, on coercion,
Okay, from all.
From all, Lordship, from most of the beneficiaries, that promissory note was taken, Lordship. And blank check was taken, Lord.
Okay, so this is dated, post dated 15/2. You received compensation on 18/2.
Yes,
Okay, now after receipt, you don't want to pay.
Lordship, what had happened is, Lordship,
Hmm.
after coming to know, Lordship,
Hmm.
that he has taken this particular check on coercion, Lordship, by misleading
No,
us,
no,
Lordship.
just a minute, huh? So it was credited in your account.
The amount
So,
was credited.
when the complainant presented the check?
15th February 2026, Lordship will.
15 February, it was not yet credited in your account, the compensation
So
also.
why, Lordship? So why,
Okay.
Lordship?
Okay. Thereafter also, so after that, yeah, after 15 days, he gave notice to you.
Yes. In that note, in reply to that notice also, we have clarified our stand, Lordship.
Okay.
Clearly stating that that particular promissory note was executed under
Now,
duress.
where is your complaint? Let us see.
Page 108, Lordship.
108.
8. Annexure 16, Lordship.
No, this is recently only. Recently only, when you decided not to pay, then only you filed this FIR. What I'm asking is immediately after they have received or after signing this, when you realize that this is illegal, you did not file any FIR at that time?
Lordship, FIR at that time was not filed, Lordship.
Okay. Now what can we do? You promised to pay.
Lordship,
Hmm.
that so why, Lordship. At
Hmm.
that point of time, this promissory note was executed. It was taken from me, Lordship, and then the blank check was taken from me by the chairman, so-called chairman, Lordship.
You also thought that you are going to get, if you really get this much of amount, you will pay, you thought.
So why, Lordship?
Hmm.
That itself, that promise itself is
Now-
illegal, Lordship.
Hmm.
My argument will be, Lordship,
Hmm.
that promise itself is illegal, Lordship, in the eye of law.
Hmm.
Why? Because, Lordship, that particular debt that at that point of time which the complainant says that has incurred, it's enforceable
In
debt.
a minor, whether it has it been decided that it is for the use of the committee or for the society, some such and such percentage of amount will be charged from each and
No, Lordship.
person.
No such,
No.
no such,
Nothing.
nothing, Lordship.
So what you have, what is the allegation in this
Lordship,
FIR? This is also very long FIR. What is this? FIR or what?
yes, Lordship, this is the FIR, Lordship.
Okay, all the person,
All the person, Lordship.
okay, all of them against only one person.
Only one person. And another person also coming, after coming to know that he has taken that particular check,
Any one of
page 65, Lordship.
wh-
Page
whether-
65. Who is the secretary in this case, in which name the promissory note was entered? Another person.
Hmm.
He has also served one legal notice, Lordship,
To whom?
to the president, Lordship, chairman.
Okay, he is also in the committee,
He is also in the committee, Lordship.
but then he didn't know. He has no knowledge about.
He does not have knowledge
that
about
is
the
why he-
promissory note. So he wanted
Notice for the legal
wanted the
notice is
chairman-
saying what?
to return that promissory note and the blank check, Lordship.
Okay, okay,
That legal
So-
notice will find at
so
page
what-
65.
okay. What you have said in this complaint? Where is the relevant portion where you have made an allegation that it was illegal? Okay, anyway, what we'll do
Page-
at this stage, we'll issue notice.
Lordship, that complaint case that is pending, Lordship.
Complaint case, what is the stage?
Lordship, summon has been issued, Lordship.
Someone,
Cognizance has already been taken, Lordship.
you contest.
Lordship, this is, Lordship, apparently, it is a case where
See,
The-
you have filed this FIR. Has it been registered?
registered, it's registered.
Yes, you can. you
The
can
case is-
contest. Hmm.
That the inquiry also was conducted, Lordship, that I have annexed, Lordship. Preliminary inquiry was conducted.
Where?
It's completely going against the complainant, Lordship,
Where?
page 125, Lordship. Page 125,
Inquiry in which case?
into the FIR filed by us, Lordship.
Okay,
And thereafter, Lordship, this is the preliminary inquiry that was submitted before the SP, Lordship. After getting this inquiry report, SP has directed to register that FIR, Lordship, page
okay.
120.
Now, has it been registered?
Yes, it is registered, page 130, Lordship.
Just a minute. One
135 is the,
registered against a respondent. 135.
yes, against the
There is
response.
no 135 pages.
130, sorry, 130. Lordship, 130. And except 20 years. Lordship, will see at serial number 7 of the FIR, Solemso Ama. He's made is the accused, Lordship. All those promissory note check, all those has been seized by the police, Lordship. The investigation are being carried out, Lordship.
Okay, the check has now been seized.
Seized by the police.
Okay, what do you want now?
Lordship, that complaint case that is pending before the CGM court, that has to be state, Lordship. And I'm seeking quashing of that particular complaint case itself, Lordship. Since the way that promissory note was executed, the way the blank check was taken from us, that was not for an enforceable debt. The agreement that was entered, that itself is illegal, Lordship. Now, for that brokerage charge, Lordship, can a chairman of a committee,
Mr. J. Gini, Land Council for a petition. Oh, who are the part? No, only Solemso has been made as a party. Solemso. Para. By this application under section 528 of Bharatiya Nagarik Suraksha Sanhita 2023, the petitioner is praying for quashing of the criminal proceedings in complaint case number CR number 18/2026 pending in before the court of the Chief Judicial Magistrate, Lohi District. Under section 138, read with section 142 of the Negotiable Instrument Act 1881. And someone order dated 5/6/2026. Passed therein. And all passed therein and all proceedings in the case. Stop. Para. we'll just simply issue notice at this stage. Okay,
Lordship,
issue notice.
Lordship, I'll pray for stay of the proceeding. Why? Because Lordship, it will be an abuse of the process of the court, Lordship.
The petitioner shall take steps for service of notice upon the respondent by speed post as well as by usual process within a week from today. Staff and para. List is matter Arthur. The call for the scanned copy of the trial court record. Staff. List is matter after 4 weeks. Staff para. In the meantime, and having regards to the contention made in the petition and the submission of the land counsel for the petitioner, in the meantime, it is provided, in the meantime, the further proceeding, it is provided that the further proceeding of the, what is the number you said? CR case, the complaint case number being CR number 18/2026 before the Court of Chief Judicial Magistrate shall remain suspended till the next date of listing. Okay.
Yes.
Till the next returnable date.
Okay.
Okay.
Item number 4,
Lordship, or also same, Lordship. Arising,
Similar order.
same.
Hmm?
Same order. Can be.
4.
Only the complaint case will be different.
Okay. Complaint case. Will we be able to buy? Case number will be different, huh? Right, complaint case number. Complaint case being CR number 8/2026. Okay.
item number 5,
Lordship, may I?
Hmm.
Lordship, this criminal petition is jointly filed by the petitioners praying for setting aside and quashing of the criminal procedure in GR case number 841/23 corresponding to Dimik case 64/22, Your Honor. On the strength of deed of agreement, deed of settlement arrived between the parties. Your Honor, may I read the FIR?
Yes, sure.
Your Honor, Lordship, FIR is at page number 13.
Case?
Page 13, original FIR, and type copy is page 14. Lordship.
Okay.
It is to inform you that on 12/10/23 at around 7:40 p.m., one so and so same village entered into my construction building at Gumto 3, village Gumto, and stolen away my tiles. And in the meantime, both the alleged culprits have been red-handed and recovered 6 packets of 2x2 tiles from their position from the jungle. They confess they are guilty. It is also that might have involved similar crime the earlier too. Therefore, your good office is requested to take necessary action under the suitable section lawfully. Your Honor, here in this matter, the complainant has engaged the petition number 3 has engaged petition number 1 and 2 to do the plumbing works at his under construction building at Gumto, Your Honor. And during the time this alleged incident had happened, Your Honor. However, Your Honor, the complainant and the
Who is the informant complainant?
Lordship, it's petition number 3,
3 is the,
complainant.
okay, and 1 and 2 is the accused.
Yes, Lordship. Here the petition number 3 and petition.
What happened? The case has been charged sheeted?
Yes, Your Honor, the case has been charged sheeted and it's
Let us see, where is the charge sheet?
charge sheet is at page number 15 onwards, Lordship.
Registered under 440.
448,
Wait, what is 448?
448 is for half stress password, Lordship.
Okay. The charge sheeted under?
And 380 is for theft in
Same.
theft in dwelling house, Lordship.
Same. Okay. Same offense.
Here, Lordship, 380 is non-compoundable. Therefore, I have abstained before this honorable court.
Yes. What happened, charge sheet, then cognizance taken?
Lordship, cognizance taken and
Where?
charges were framed under copy of charge frame order dated is on page number 41, Lordship.
Hmm?
Page number 41.
Okay. Then
And
evidence
there is-
recorded?
Yes, sir, only one PW1 has been recorded. Your Honor.
Hmm?
Only one PW1, only one witness.
Okay. So now
Now,
they have settled.
yes, Lordship.
What is the condition of the terms and condition of the settlement?
Not to further pursue the matter. They are very known to each other. Your Honor. Even the children of the complainant are friends with the eligible person. They went to the same.
Mhm.
Your Honor.
There?
They are known to each other, Lordship. Even the children of the complainants went to the same school as the alleged accused person. They have a residence within.
Accused is a student.
No, Your Honor. What I'm submitting is no. The complainants, children, and the accused persons, they went to the same school, so they are very well.
Complainant children and the accused person.
Yes, Lordship.
So complainant's children, and the accused is a student then?
No, during that time, Lordship. When
Okay,
they were
okay.
students, Lordship. So, what I mean to submit is that they are very known to each other, and they live around
Okay.
half-kilometer radius.
Okay, yes.
Lordship, since Sarge was framed, CC was framed on 6/11/2024, Lordship, and there is 6 prosecution witness, Lordship.
How many of them have been
6,
examined?
only one, Lordship.
Only one.
And there is no record, updated record, Lordship. So maybe.
You want the record to recall?
Yes, Lordship. Record
At-
may be called for.
Proceed a stage.
Yes, Lordship.
Can it be tomorrow?
No, it no.
Scan copy?
After break, Lordship. I have no objection if this is a proceeding or state, Lordship, but at least we have to see the record, Lordship.
Okay,
Otherwise, Lordship, it's a joint.
okay. Heard Mr.
K. Parang, Lordship.
Parent counsel for the petitioner. Also heard Mr. Loy. Then a PP for the state. Otherwise, this is
Yes, Lordship, but
it's only tiles,
yes, Lordship.
few tiles,
Yes,
recovered also.
yes, that part Lordship, I understand, but
Hmm.
trial maybe conclude, Lordship. There is no record showing that since CC was framed only on 2024, Lordship.
Okay.
He's come after 2 years, Lordship.
Para. This application under section 528 of the Bharatiya Nagrik Suraksha Samhita 2023 has been filed jointly by the accused and the informant, praying for setting aside in quashing of the criminal proceeding GR case number 841 stroke 2023 registered under section 448 380 34 IPC on the ground that the matter has amicably been settled between the parties and that the accused applicant having been pardoned by the informant on the ground, the accused, no, the informant, already pardoned the accused for their mistake and he does not have further grievance. And he has no further grievance against the accused persons and does not wish to pursue the matter any further. Stop. Compare issue notice.
Lordship, in the interim, the
Okay.
trial proceeding may be stayed.
Okay, Mr. Loy seeks some time to produce the status report, status of the trial of the case. Stop. The prayer allow. Stop. List this matter. Okay, just a minute.
Lordship,
Since issue notice, since Mr. Loy, Leonard BP, accept the notice on behalf of the state respondent, no formal notice is required to be issued. Stop. Call for the scanned copy of the trial court record. Stop. Para. List this matter
Lordship,
on we'll say 23
any date, Lordship.
or 21. Okay, we'll say 21. Okay,
Lordship.
21.
The-
21 July. Stop.
I have apprehension, Lordship, that trial may be concluded, Lordship.
Okay, stop.
Since
Let us see then in that case.
yes, nothing,
When the next date is fixed, do you know?
Lordship, it's next Monday, this Monday, Lordship.
It is fixed for what?
Evidence, Lordship.
Evidence of
Evidence of PW2 entry. Lordship.
20. See,
Otherwise, Lordship, it's a joint petition. It may be disposed of during the motion only.
no, he has some doubt on you. Looking at
This
you,
will come with Lordship.
Yeah, hey.
At least. it is
that
closed.
the trial must may have concluded.
There is only 6 PWs, Lordship.
Hmm.
That is
Okay,
right.
21. Okay,
Lordship,
21.
Stay may be granted, Lordship.
Okay, and until then, the further proceeding of the TR case number say so and so, shall remain stay till the next date of listing. Okay.
Highly obliged.
Matter number 6,
Your Lordship, this is a joint petition for quashing the FIR Women Police Station Teju case number 02/2021, registered under section 354 and 354, 498A and 34 of IPC, Your Lordship. So parties have settled the matter, Your Lordship. So
3. What is the allegation say?
Your Lordship,
Where is the allegation? Against my. Okay. So what happened? Charge framed, charge sheet filed.
yes, Your Lordship, this is currently at evidence stage, Your Lordship.
Okay.
They were a married couple, but since 2020, they are living separately and mutually divorced,
2020.
Your Lordship. Yes, Your Lordship. So meantime, that petitioner one lodged a complaint which is still pending before the CGM Teju, Your Lordship.
Petitioner lodged complaint against
This petition number 2 and 3, Your Lordship.
who lodged complaint?
Petitioner number 1, Your Lordship. Samiti Primansai Mepo, Your Lordship. Samiti Primansai Mepo, who is complaining, Your Lordship.
After this, another complaint or what?
No, Your Lordship, only one complaint was lodged, which is still pending. But they
Which
have
one?
settled the matter, Your Lordship.
Which one?
This one, Women PS case Teju 02/2021, Your
I
Lordship.
thought different from this.
No, Your Lordship.
Okay. Who is the informant complainant?
Complainant is petitioner number 1.
One is the complainant.
Yes, Your Lordship. And
petitioner number 2 was her husband, and petitioner number 3 was her brother.
Okay, when the complaint was lodged? 21. They are staying separately since when, you said?
2020, Your Honor.
2020.
Yes, Your Honor.
Now, this is, the complaint was lodged after separation.
Yes, Your Lordship.
Some issues, children are there.
No, Your Lordship. No children.
Where is the, just a minute, this is complaint. Investigation charge sheet filed against accused under same offense. The case has been charge sheeted pending before the court.
Yes, Your Lordship.
Charge sheeted under what charge frame?
Yes, Your Lordship.
Where is the charge sheet?
Page
Under which,
7, Your Lordship.
where is the offense section mentioned?
Okay.
Okay. Where is the
Last portion of page
charge
28.
frame, where the when the charge was framed? When charge framed against the accused? Charge already framed or not yet framed?
Frame, Your Lordship.
Where? When? Where? Have you annexed? We'll have to call for the record then. You should come prepare. If you want a quick disposal.
Your Lordship, Annexure 1 is the recent order, Your Lord.
Where is the charge framed? When charge was framed? Where have you stated?
Lordship, last order is page 17, Lordship.
I've seen that.
Lord.
Where is the order, charge framed order? Do you have any information? How many witness has have been recorded by now?
Lordship, we need to call the records, Lordship.
Okay, same. Mr.
P. Wangpan, Your Lord.
Okay, land counsel for the petitioner. This is an application file under section 528 of the BNSS. Praying for quashing of the, where is the GR case number 3/2021, arising out of the Women Police Station case, Women Police Station Teju case number 02/2021 under section 354 and 498A. 354, 498A, 34 IPC. Pending before the court of the chief, which court?
CGM Teju.
Chief Judicial Magistrate Teju. Staff, Hard vote, petitioner and El Hage, huh?
Your Lordship, interim may be granted, Your Lordship.
Hmm?
Interim,
Para, issue notice. Since Ms. El Hage appeared, accepted notice on behalf of the state respondent, no formal notice need be issued. Staffer, call for the scanned copy of the trial to the court. Staffer. In the meantime, the proceeding of GR number 03/2021 arising out of Women PS Tejo case number 02/2021 pending before the Court of Chief Judicial Magistrate Tejo shall remain state till the next returnable date. Okay? What's up? List is again on 21 July. Yeah, no, 21 is a DB there. When?
Immediate.
How many cases have been fixed in 21, on 21?
For single, only two, Lordship.
Huh?
Only two matters.
Okay. 21.
21.
Problem.
Item number 7.
Your Lordship, this is also similar case, Your Lordship. Parties have settled the matter, Your Lordship.
Similar case means
Joint petition, Your
parties
Lordship.
are
for
not
quash-
staying together.
No, Your Lordship,
Not similar case. Facts are different. It's a case of theft.
parties have settled the matter, Your Lordship.
Record need to be called for or what?
Yes, my lord, my lord, perhaps the records are need to be called for because my lord, even we have experienced some cases wherein some of the facts have not been properly disclosed by the
Right.
petitioner, my lord.
Hmm.
So record need to be called for.
Okay.
my lord.
Similar order, party change, Mr. APS name will be there. And then the case number is, Itanagar Police Station case number 145,
24.
2024, register under section 305A,
Small line.
small a of BNS. This is GR case number 875/2024, arising out of Itanagar PS case number, 145/2024. Notice accepted, then call for the scanned copy of the trial court record. This is also joint petition.
Yes, my lord,
Yes,
join.
my
my
lord.
lord.
Okay, trial court record. List, no, on the same day,
Your Lordship, interim may be granted.
My lord,
21, is it okay?
let it be on my lord, August, my lord, there is no any urgency, my lord.
No urgency.
No urgency, because my lord, the other many cases are fixed immediate after vacation, my lord.
Right,
So this is already a settled matter. We have to only verify, my lord, whether it's a genuine, the other sections are there or not.
21 is fine only.
Okay, my
21,
lord. Okay.
We stay again, till then. Okay.
Most of
Obliged.
Item number 8.
Yes.
Your Honor, in this matter, Your Honor, I seek to
Okay,
mention for adjournment, Your Honor.
yes. Mr.
C. Natung. C. Natung.
Lana Council. C.
Natung.
Lana Council for the appellant. Who submits that? Earlier, this matter was referred to the mediation for settlement. However, the mediation failed. Due to the, whether here before this court, whether the respondent appeared,
Respondent remain absent here.
remain absent since then.
Yes.
You did not take, step property, it appears then.
Service was taken, Your Honor.
By what way?
Registered post, Your Honor.
Okay. Okay. Then in view of the above, let this matter be listed for. It will be for admission
Yes,
after 3 weeks. Okay?
okay.
Mm.
And
Item number 9,
Mm.
May I please, Lordship? Lordship, this case is related to the NIA check bounce case.
Hmm?
Lordship, check
Bounce case.
complaint,
Okay.
Lordship.
6 pounds. 6 pounds.
Yes, Lordship. Lordship, here, what happened? When the complaint is filed before the magistrate has to comply the mandate under section 225 of BNSS, Lordship. Lordship, when there is a complaint, and if the accused person is
Just a minute, whether the other side, who is for the,
I'm for the response.
okay, yes, yes. Wakalat Nama filed. This is listed for
Admission, yes.
admission. Okay. Both are ready otherwise.
I will take 10 minutes.
Okay.
very small issue, Lordship.
Hmm.
Lordship, here under section 225, when complaint is filed,
Mhm.
under 225, what the learned magistrate has to do is to see whether the accused person is residing within the jurisdiction of that particular magistrate or not, Lordship. If the accused person is not residing within the jurisdiction of this honorable court, now there will be two procedures. First, he has to postpone the process, stop the process for time being. In the meantime, he has to carry out inquiry by himself or direct the police officers for investigation.
In NIA case.
Yes, in complaint case, not only NIA, in
Hmm.
every complaint.
Yes, yes, that is it.
Now here, Lordship, instead of complying this 225, now they directly admitted the complaint and someone was issued to the accused.
Not examine the complainant.
No, not examined. This is my case, Lordship. So may I take it to Lordship 225 provision? Section 225, yes.
Of BNSS.
Yes, Lordship, BNSS. May I read provision, Lordship?
Just a minute. Just a minute. Two to five.
Yes, Lordship.
That is. Yes.
Here, Lordship, 223 is the examination of the complainant. When any complaint is filed, the complainant has to be examined. And 225, Lordship, postponement of issue of process.
Hmm.
1. Any magistrate on receipt of a complaint of an offense of which he is authorized to take cognizance or which has been made over to him under section 212 may, if he thinks fit, and shall in a case where the accused is residing at a place beyond, Lordship, beyond the area in which he exercises his jurisdiction, postpone the issue of process against the accused person and either inquiry into the case himself or direct an investigation to be made by a police officer or by a such other person as he thinks fit. This is my case law. Now, when the present respondent has filed a complaint before the magistrate without complying this 225, since the present petitioner and the accused in the complaint, he resided beyond the jurisdiction of that London magistrate.
What he had, he for a purpose of deciding whether or not. So without complying this, what did he do, you said?
He has, Lordship, issued the process and someone was issued to the accused person is directly, Lordship. In fact,
Someone
he
was
has to
issued?
get a complaint, yeah.
What the magistrate could have done according to you?
To me, as per this 225 Lordship, he has to process regarding that complaint. And since the accused are residing beyond his jurisdiction, he has to make an inquiry by himself or to direct the police officer for investigation, Lord.
For what?
For the complaint, allegation made in the complaint.
Now, in that case, that means the police is to be directed to investigate the case.
Yes, either he himself inquiry or.
No, this is a complaint before the magistrate, straight away.
Yes, Lord. So,
Complaint before the magistrate.
yes, Lord.
Magistrate, whether before issuing of this summon had examined the complainant?
Yes, he has to examine the
No,
complaint.
whether not examined here in this case.
Examine, Lordship.
Examine.
Examine.
Then what is wrong?
Thereafter, Lordship,
Hmm.
if the accused is found to be residing beyond his jurisdiction, in that case, he has to comply 225. Lord. This provision, Lord.
Compliance means
Means he has to see if the accused person is residing.
now he knows that he is out of he is residing out of the jurisdiction. Then what he need to do now?
He has to make an inquiry by himself.
Now he knew that it is beyond his jurisdiction.
Yes, Lord.
You are residing beyond jurisdiction. What he could have been done according to you?
He has to inquiry about the complaint, Lordship, whether.
No complaint. You said that he was already examined.
That examine, Lordship, that is pertinent to the complaint application only.
Yeah.
He has seen the complaint petition
Mhm.
and then directed the produce all those check, Lordship, also.
No, after examining only, having found or satisfied, or probably cognizance taken,
Yes,
thereafter only notice issued.
yes, Lord.
What is wrong there?
But here provision, it says, Lordship.
No, he knows that the address, from the address, it is clear, it will be clear, prima facie, it will be clear
Yes,
that he is out of his jurisdiction. And after satisfying himself, after taking cognizance only, he issued summon. What is wrong in it?
But-
what more is to be inquired?
inquiry regarding the whether the claim of the complainant,
Uh,
whether the check was issued by the accused person or not. And how check was issued.
Now, if he appear, then only it will be known.
For that, yes, Lordship, before appearance of the accused person,
Hmm.
he has to make an inquiry by himself to authenticate the check issued.
Is it,
claim by
is
the
it
company.
know the procedure where on receipt of the complaint,
Yes,
the magistrate will examine
yes,
the complainant,
yes,
and then after that, he will take cognizance. If he is satisfied with, prima facie satisfied with the complaint of the complainant, then he should process.
yes, Lordship.
Is it not the case?
Yes, that is the case.
Hmm.
While examining the complainant, Lordship,
Hmm.
if the magistrate is found that accused is residing beyond his jurisdiction, then he has to comply 225 before taking cognizance. Lord.
Compliance by what way?
By making inquiry by himself or direct it to the police authority for investigation. Then,
Further investigation.
yes, further means, Lordship, it was only mere complaint filed by the complainant, Lordship.
No, you
Well,
said that
this-
he was examined thereafter. What is the submission? Just a minute. Huh?
Yes, yes.
Huh.
Well, in this case, what has happened? On 22nd of July 2025,
Hmm?
the 22nd of July 2025,
Hmm.
the Lenat trial court took cognizance of the offense
Hmm.
by examining the complaint
Yes. Hmm.
and postponed the issuance of summon
Hmm.
with a direction to the complainant to file his evidence on affidavit and documents in original.
Mhm.
in compliance with that order, the complainant filed his evidence on affidavit and original document.
Mhm.
It is only thereafter, after perusing the evidence on affidavit.
He was also examined.
Yes.
Okay.
So it is only after perusal of that evidence and documents, the learned trial court has issued summons
Okay.
on 22nd or 21st of August 2025. That order is put to challenge. Now these are admitted facts. These admitted facts brings us down to only one issue. That is, what is the scope of inquiry under 225? In my humble submission, Your Honor, the scope of inquiry under 225, in suitable cases, the magistrate can restrict that inquiry to only examination of documents without insisting for evidence on evidence of the complainant. And even examination of the complainant can be done by way of affidavit. That is the law.
Here is a case where the complainant was already examined initially.
On 22nd of July 2025, when the cognizance was taken,
Hmm.
he was not examined.
Not examined.
Not examined.
Okay.
Subsequently, when summons were issued, then he was examined. After
No, before issuance of summon.
before issuance of summons.
After examining him only,
Yes.
the summon should be issued.
Yes,
So he was examined.
examined. Therefore, there's no illegality in the order.
Okay. And after postponement
Yes.
of the process,
Process.
so he was directed, the complainant was directed to file the document,
Yes. Yes.
evidence.
Your Honor, will kindly come to page number 29. That is the order dated 22nd of July 2025. Relevant page 29. Annex
29.
dated 22nd 7th 2025.
Where the record was called for, record is there. Okay. Yes.
Page 30, relevant paragraph, paragraph 5 and 6.
Hmm.
In light of the above, the ingredients of section 138 NI Act is found satisfied, meaning thereby the cognizance has been taken. Hence, the complaint under 138 NI Act is admitted. However, it is noted that the complainant has not filed his evidence by way of affidavit. Hence, the complainant is directed to file his evidence by way of affidavit along with supporting documents in original for
Hmm.
perusal.
And this was filed.
That will be fixed for consideration of summoning the case.
Okay. Accordingly, the complainant filed
Yes.
document.
And the impugn order is at page number 21/8/2025. Sorry, page number 32. 32. Where the complainant is personally present along with learned counsel such and such, and material exhibit marked as 1 along with certificate under 63(4) of BSA is also enclosed. Issue summons to accused person. The complainant through his learned counsel shall take steps. Let the matter be fixed on 23/9/2025 for appearance or service. The evidence on affidavit of the complainant and one of the witnesses is part of the TCR.
Yes.
Look, the impugn order has been fundamentally challenged only on the ground that the trial court, before issuing summons to the accused person, has not followed 225. Whereas the orders dated 22/7/2025 and the order dated 21/8/2025 clearly shows that the trial court
before issuing summon has followed the prescribed procedure under 225. On 22nd, cognizance was taken, but issuance of summon was postponed with a direction to the complainant to file evidence on affidavit and submit original documents. It is only after perusal of the evidence and supporting documents that the learned trial court has issued summons on 21st of August 2025. So this, according to you, does not fulfill the requirement under 125,
Lordship,
225, sorry.
my submission would be basically on two, under, first is 2 to 3, examination of the complainant, and then 2 to 5. 4, as my friend has submitted, that cognizance was already taken on the date of 21. But before cognizance also, Your Honor, now this BNSS may take you 2 to 3, Lordship, examination of complainant. How the examination complainant has to be examined, and how cognizance has to be taken in the complaint. 2 to 3, Lordship.
Two, 2, 3.
Yes. The complainant's
Yes, equivalent to
examination of
200.
complainant. Then this 2 to 3 provision also.
Mhm.
Provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. Here also, Lordship, the cognizance was taken in absence of the accused person.
My lord, this proviso is not applicable to cases under NIA. It is not applicable to cases under NIA. NIA.
And Lordship, 2 to 3, the examination of complainant here, the purpose of these provisions and insertion of 2 to 5, postponement of issue of process. This examination and this inquiry under 2 to 5 is both different, Lordship, procedures. Examination, Lordship, when the complaint has been filed, of course, the complainant, his statement, affidavit, everything, that is on the part of the examination. But while examining the complaint, Lordship, if the learned magistrate found that the accused is residing within, beyond the jurisdiction, then Lordship, 2 to 5 will come into play, Lordship. In that case, he has to stop the process and to inquiry himself or direct the police officer for investigation, Lordship. Otherwise, if the inquiry is, the purpose of 2 to 5 is covered under 2 to 3, examination of complainant, then of course, Lordship, the insertion of 2 to 5 does not arise the postponement of the issue of process. That is why, Lordship, in absence of the accused person, they admitted the complaint, cognizance was taken, and issue summons to the accused person, Lordship. This inquiry and examination of complaint under 2 to 3 is the different, both different proceedings, Lordship, procedure prescribed under the law. And regarding this provision, Lordship, if this is not applicable, then I'm extremely sorry. I am not aware about this, whether this is applicable to NIA.
So how it is not applicable, by the way?
Well, there's a judgment.
Hmm.
It says that NIA Act is a special act. The very objective of NIA Act is summary procedure. Therefore, key cognizance hearing would defeat the very objective of speedy trial.
That is true, this summary, but can you just?
Sorry?
Can you just place?
There is no.
State has also been made party.
No.
No, Lordship.
I have.
Santosh. Got it.
Now, examination under 223, that is argument which
will
my
come after, yeah.
Lordship,
Yes, what was the section which according to you is not applicable in the NIA case?
proviso to 223.
Okay, not 225.
225 is applicable, but
Okay,
223
applicable.
proviso that pre-cognizance hearing
Hmm.
not applicable.
So, what is your prayer?
my prayer, Lordship, that,
To such as request someone only,
yes,
not the complaint itself,
no, not,
to remind it back
yes,
to comply with the 225.
225.
So,
Your Honor, it can be remanded back. Ultimately, I am the one who's suffering because,
okay,
because of the interim order, the proceeding has been stayed.
okay. Here, even if it's not required also, not required also, but then examination, as you say, that the complainant was already examined, isn't it?
Yes.
Hmm. Hard, Mr. Lole, land counsel for the petitioner. Also had Mr. John Pungon, huh? RL, huh? Pungon. Land counsel for the respondent.
Yeah, not applicable. Not applicable, Lord.
By this application under section 5 to 8 of the Varpina Riksuraksa Sanhita 2023, the petitioner assailed the order dated 21/8/2025 passed by the Landed Court of Chief Judicial Magistrate Bomdila, West Kamen in NIA case number 3/2025, whereby summary was issued against the petitioner number 2. There is two, how many petitioners are there?
Only one, Lordship.
Someone was issued against petitioner number 2, you said,
Single petitioner,
21st of August 2025.
page 2,
page 27 and 31.
no, page 2, kindly see. Someone against the petition number 2, as well as the continuation of the proceeding in the,
Yes, wrongly mentioned,
okay,
petitioner 1.
Then-
Again, the petitioner.
petitioner, huh? There, it is submitted that before issuance of the summon, the Landed Court is required to procedure under section 225
Please complete that, Lion.
of the BNSS, whereby it is provided that in the case where the accused is residing at the place beyond the area in which he exercised his jurisdiction, postpone the issue of process against the accused, and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as he think fit for the purpose of deciding whether or not there is sufficient ground for proceedings. So, however, in the instant case, the learned magistrate has taken cognizance of the complaint without giving an opportunity, and issued the summons without giving any opportunity to the petitioner, the respondent, and following the procedure as required under section 225 BNSS. Staff. Mr. R.L. Thongonlani counsel appearing on behalf of the respondent clearly submitted that in the instant case before issuance of the summons, the procedure under 225 BNSS has not been complied with. Staff. In view of the above submission and as in view of the above submission and considering that the provision under section 225 has not been complied with, this court is where is the impugn order?
Impute lordship, yes, page 27 and 31 lordship,
Okay.
page 31.
This court is of the opinion that the petitioner has made a prima facie case for interference of this court. Accordingly, the order dated 21/8/2025 passed by the learned Chief Judicial Magistrate Bombilla West Cumming in NIA case number 03/2025 is set aside, thereby set aside. The matter is remanded back to the trial court to proceed with the to comply with the provision under section 225 BNSS and to proceed with the trial of the case in accordance with law. Okay.
Deeply obliged. And lordship, once again, I'm extremely sorry about that provision.
What provision?
That are not applicable in the NIA case. I am not aware about 2 to 3 laws.
Okay.
Provision.
But it was already complied with.
But
2 to 3.
regarding
Examine. You said that already examined.
provision is regarding cognizance lordship.
Okay.
That I was not aware whether it is applicable to NIA case or not.
Okay.
I'm extremely sorry.
Item number 10,
May it please your lordship.
Yeah.
Your lordship, by this repetition, the petitioners are challenging the rustication order dated 13 January 2026, by which your lordship, the petitioners have been rusticated from the respondent school.
Rusticated.
Your Lordship. And your Lordship, though there is paucity of time, I pray that this matter will be disposed of today, except your Lordship. Since
Due
the
to
test of
paucity of
admi-
time? Why? If there is a paucity of time, why should we dispose of?
So your Lordship, my prayer before this honorable court is that the respondent school is prematurely taken, subjected the petitioners to severe stigma and harsh punishment
No, what-
by way of rustication. Your Lord.
You are agreed by what?
Agreed by the rustication order.
Rustication. When it was passed? When it was passed?
13 January 2026.
13.
Yes, your Lordship.
When did you file this?
And this petition was filed on 4 June, your Lordship.
Oh, what is the order on, what order was passed on 10/6?
On 10, your Lordship, this honorable court, your Lordship,
Is there any stay order? No.
an interim order was passed,
Interim order was passed.
wherein this honorable court was not inclined, your Lordship, to waive the reimbursement amount.
Hmm?
There is what, two issues are here, there, you know.
Uh-huh.
Number one, the petitioners have been rusticated from the school, and now they are not considering them for readmission Number
Not
two-
considering there?
readmission in the respondent school.
Okay.
And number two, your Lordship, now to obtain the transfer certificate, the petitioners have to reimburse all the amount they have obtained they have obtained from the school, your Lordship, reimbursement amount, scholarship amount obtained from the school,
School has given some scholarship to the
Yes.
student.
from state, central.
So now the school authority says that has to be reimbursed.
Yes, sir. Only then the transfer certificate will be issued.
Transfer certificate.
Yes, your Lordship. To the
You are in which class?
class 10, I'm seeking admission to class 11.
Class 10 result out.
Out, your Lord.
You pass.
We have passed.
And then they are not giving admission.
In class 11.
Class 11, they are not giving admission.
Yes, your Lordship.
Okay, and then not also not giving certificate.
Certificate on the ground that as per the rules, whoever leaves the school institution, they have to reimburse the scholarship amount.
Scholarship you have already received.
Yes, your Lordship.
When?
Every year, there's some,
No, scholarship means scholarship for which period? Is to
Oh.
be refunded.
on the time of admission to till that, your Lordship.
Is there in the rule?
Similarly,
Is there in the rule? Is that in the rule?
in that rule, your Lordship, the rule they are relying, your Lordship.
You follow the rule then?
No, that's not applicable, your Lordship.
Not applicable.
Yes, your Lordship. As per that rule, your Lordship, the reimbursement will be given only if the wards or the parents, they voluntarily leave the school, your Lordship, withdraw from the school. But here in this case, the
Well,
parents.
then
are
we
being
need to
rusticated.
go through the rules then.
Yes, your Lordship.
What the rule says? Is it compulsory?
But at this stage, your Lordship.
Just a minute, huh?
That particular, the rules is not specified, Malan. This is something, Malan, different. The peculiar situations, Malan.
No, in such circumstances, what the rule says, in such circumstances where the students have been rusticated, so what is the rule?
That's why,
What
Malan,
the rule says?
my point is, Malan, my submission is, Malan, in case of rustication, it is not mentioned. It
Not
is
mentioned.
not mentioned. Malan.
Only in case
In between,
the ward wanted to withdraw.
yes, Malan. Malan,
Sorry, the
if Malan, in the mid of the academic session,
Hmm.
if wanted to withdraw,
Hmm.
Malan, there is a Malan, the provisions by which Malan, the school is insisting.
Here in this case, what is to be done according to you?
Malan, rustication is for that the offense, the least to be
It's a
committed by
punishment.
them, punishment, Malan.
Hmm.
And punishment is something different that has to be looked into by the school organization, man, school institution, man.
Mhm.
And that is the separate aspect, man. And if really the petitioners wants to withdraw their words from the so and so. man,
Now,
the
you are not
process-
giving admission also?
Man, the admission is not giving is because the rustication is there, man.
Okay, then what alternate they have now then?
Alternate, man, they have to wait till the revocation of the rustication or other, man,
Are you taking steps to revoke the rustication order?
Malad, as per the instruction given by the school authorities, Malad, yes, the department institution is working on it, Malad.
Okay. When it is expected to be,
Malad, that aspect, Malad, have not received the full instruction, Malad, but the principal said they are, Malad,
taking
initiating,
steps?
taking
Because
steps.
see, one way the children are rusticated, of course, there has been mistake if there is. Children have been rusticated.
Malad.
If you give admission, it's fine. But you are refusing to give admission also, not taking them back.
Yes.
And then also refusing to issue certificate. Then where do these people go?
Malad, as I pointed out,
Hmm.
till the outcome of the rustication order, that if that is
Can
considered,
you just obtain instruction? Just tell them that because the children now need to take admission in class 11, 10 pass.
of course, Malad, in the rustication order, Malad,
Ah.
everything has not been stated. But then, this will be not, Malad, kept so long as they wish, Malad.
Yes.
On this issue, Malad, it has to be, Malad,
No, not for indefinite period.
Malad, exactly, Malad.
Hmm.
For that, Malad, they have to make an application before the authorities concerned
Hmm.
for revocation of the rustication.
Have you made any?
Yes, Your Honor. Representation
So-
has been submitted.
So
Okay,
that
when?
will be,
On 24th May 2026.
24th May.
Yes.
You consider
Malad,
either
Malad-
this way, that way.
Malad, yes, Malad, that will be taken into consideration,
Hmm.
Malad, whether it is fit to be, Malad, revoked.
Yeah,
The
revoke or
rustication
not.
or not. As per the Malad, the instruction of the principal, Malad, they are working on it, Malad.
Mhm.
But it is not, Malad, definite when this will be considered, Malad.
Process has already started.
That is one.
Have you filed any affidavit?
No, Malad.
No, then in that case, probably this is urgent.
Malad, as per the last, the order passed by this honorable court,
Hmm.
Malad, if they want to withdraw their words,
Hmm.
Malad, the procedure has to be followed, Malad. And if
Yeah.
they want to get, their words readmission, Malad, that procedure has to be again
See,
followed.
that is why, that is why.
Restoration,
Either you just open it, either to issue certificate. If you think that after issuance of, after rusticating, they are not fit to be kept in the same school, okay, then issue certificate.
Malad, that decision
Uh,
will be taken, Malad.
Hmm.
Therefore, Malad, the rustication the order has been issued, Malad.
Hmm. Now, if you are not allowing them to take readmission, then you are compelling them to withdraw. Then in that case, you can't charge.
Malad, once the certificate is issued,
Hmm.
they will be free from the, Malad, the allegation.
Those things, yes.
Malad.
That is why. So you have to decide, I think.
Yes, Malad.
Your Lordship, by the time the certificate is issued,
Huh.
all the admission process will be closed. Your Lordship.
No, admission is going on now, no.
No,
Not
that
yet.
part, Malad, whether they will be, Malad, taken readmission or not.
Huh.
Again, that part will be also considered in the affidavit,
Because
Malad.
now they are confronted with this situation that if they ask for the certificate and you are asking for all those, how many years? That means the entire period's scholarship is to be repaid.
Yes, Malad, yes, Malad.
Now that will be a little difficult. So I think because if the rule is not clear, then you have to decide. If the rule is not clear, the school
Malad,
authority has to
Malad,
decide in
the
consultation with the higher
ratification
authority.
in the school institution is something, Malad, that has to be, Malad, obviously reviewed, Malad.
Yes.
So it
That
is
is right.
something like suspension,
Hmm.
whether they will be take readmission or not, whether permanently they will be released from the institution or
Mhm.
that has to be taken call by the respective principals,
Mhm.
and it is the government of India undertakings, the institutions. So therefore, there's so many and the other procedures involved. So therefore, the decision has to be ultimately taken by the principals,
Then what
and
we'll
for taking
do?
this decision,
we'll do,
they are
you
of
have-
course taking some time. Once decision is taken, at this stage, if at the most, we can give a directions to the principals to take decisions on this representation as early as possible, That
Mhm.
much only can be done, Even in fact, we are not asking him to withdraw. Only rustication, at this stage. It is something like the suspension of their
No,
admission.
rustication means you are not taking admission. You are not giving admission to them.
No, madam.
So
If,
that's
my
the
lord, if
problem.
it is,
And then
after
you are not
inquiry is
also
done,
giving-
my lord, if after inquiry is done, my lord, my lord, if decision comes, my lord, they will be taken readmission
if
again.
they are facing some case, that will come, it will culminate into its own, in our own
See.
course, okay, as per the law.
Yes,
only. But then this is a education and career, the question of career of the children. So,
Other
okay,
we-
so what we'll do,
At this stage, my lord, we can give a
you
directive to
take the instruction and file affidavit in opposition on or before the next date, immediately you will fix immediately after the vacation.
my lord.
We'll fix it on 20 itself.
My lord.
Sorry, 20 election.
20 is the
Okay, then
immediate
21,
opportunity.
21.
21 DB, my lord. After DB, we
After
can,
DB,
my lord.
22, do we have the election petition? Election petition again. Election petition, it will be difficult. Then what we'll do is 21 will fix,
Well.
21 for the time being. Heard, Mr. Learned counsel for the petitioner, also heard. Mr. Kato, Learned DST,
For all the rest,
for the respondent, sole respondent,
all the respondents.
all
Three
the
respondents.
respondent, okay, stop on Paris. The respondent is yet to file affidavit in opposition. Star. However, the petitioner has shown some urgency in the matter as the children's as the words are to get admission either in the state school or in any other schools. Stop. Taking into account the urgency of the matter, comma, the planet DST appearing on behalf of all the respondent shall obtain instruction and file the affidavit in opposition on or before 20 July. Okay,
Well,
specifically, no, that will do, okay.
well,
Because rule we can't say now, we
that-
can't direct,
yes.
they will let them decide, okay. Okay, as requested, comma, list this matter and again on 21,
Well,
okay.
And your lordship, one more, your lordship, prayer. In between the time, your lordship, the representation has been submitted. That may also be considered.
Okay, okay, then in his submission, the Learned Counsel for the petition further submitted. The petitioners has submitted a representation before the principal
Yes, your lordship.
of the school. Okay. The respondent authority shall consider and dispose of the said said representation on or before 20, we'll
Well.
say, okay. That will cover, I think,
Yes, well,
on the disposal, that disposal order, that will cover your annexure, okay?
keep level.
Item number 11,
May I please, my lord?
Hmm.
My lord, this bail application is arising out of the Allo Women PH case number 04/2025. My lord, there was an FIR lodged by the father of the victim. And the same has been registered as Allo PS case number 0425 under section 65 BNS and